sharp at 7 o'clock, and there we go. All right. Hello, everybody. My name is Timothy Scott, or TJ Scott, and I really prefer TJ Scott. I'm an estate planning attorney, and I'm the owner of the law office of Timothy J. Scott. And I got to tell you, I am so happy to see so many people joining us tonight. We're going to be talking about something that I know is a really difficult topic. I know this is tough. I know talking about life and incapacity and planning for after we are gone is something that's really difficult. But I also believe that knowledge is power. And today, that's what I want to give you. I want to give you knowledge. I want to educate you, and I want to really empower you to take control of this area of your life and really give you some peace of mind around it so that you know what is going to happen and that you have everything very clear in your mind. So I have some really valuable information I'm going to be sharing with you and some valuable offers that I'm going to be sharing at the end. So I hope that you'll stick with me all the way to the end of this presentation. The best way to learn here tonight is to be present with me. And I really encourage you to turn off any distractions and give yourself this time that you've dedicated to being with me. If you have other windows open, if you're trying to watch a TV program at the same time, I really encourage you to bring all of your attention here. And I always say your future self is really going to thank you for taking the time to educate yourself and for giving yourself this time to learn and this time to really absorb this information that is so important and applies to all of us. And again, if you stick around until the end, I have a couple of offers that I want to make you. The first is I want to offer you a free virtual one-on-one meeting with me to talk about the things that you have and the people that you love and exactly how you can protect them. Again, I want to give you that meeting for absolutely free because you're here with me tonight, educating yourself and looking to do the best thing that you can for your family. And I think that's something that deserves a reward. I think that's something that is noble and is going to benefit our society. So I want to give you that free meeting with me. Plus, I want to give you a bonus gift that's going to make it even easier to get a personalized and tailored estate plan in place and have me help you with that process. So I have some polls that I am going to send out here. And the first poll that I have is, do you have an estate plan? And my guess is that some people have created an estate plan before. Maybe it's been a while ago. Maybe you had minor children at the time that you did an estate plan, and in those minor children still have guardianship nominations in your current estate plan, even though they're no longer minors. Or maybe you didn't have all of the children that you have now when you did your first estate plan. Or maybe you've never done an estate plan before, and there are lots of people like that as well. So do you have an estate plan? And I've listed here a trust, a will, guardianship nominations, healthcare directive, power of attorney, beneficiary designations. All of us have probably done some of this, especially beneficiary designations. When you sign up for the retirement plan at work, oftentimes they'll ask you, who do you want your beneficiaries to be? And really, an estate plan encompasses all of these things. Sometimes it includes a trust, sometimes it includes guardianship nominations, but it almost always includes a will, a healthcare directive, a power of attorney, and then those beneficiary designations determining where things are going to go. And I'm seeing a mix that some people do have an estate plan, some people don't have an estate plan. It is mixed, and I really appreciate you sharing that with me here this evening. And for those of you who don't have an estate plan, can you share with me why not? Let me just say, if you don't have an estate plan, you're not alone. There's something like 69% of Americans don't have an estate plan, and there are lots of reasons for it. Sometimes we feel like we're too busy to get an estate plan done, and I get it. Today life is really busy, but if that's the case for you, I just want to commend you on spending the time here tonight to educate yourself and get a little bit closer and take those few next steps to getting an estate plan done for yourself and for your family. You're really on the right path and you're taking care of business here tonight. Maybe you feel like you're too young to have an estate plan or to need an estate plan. Again, I really understand that. It feels like an estate plan is something that you can always do later, right? That you can do it when you're in your 60s or 70s, 80s. You can do it while you're on your deathbed, whatever the case might be. But I want to tell you, anyone over the age of 18 should really have an estate plan in place. I recently helped a young family where a very young father in his 20s passed away. And unfortunately, he left something of a mess behind for his wife and minor daughters. But that just doesn't have to be the case. You can get this done. Young people can get a lot of these documents in place when they're over the age of 18 to really take care of their family and to take care of their assets and make sure that they go the way that they want them to. Maybe you feel like estate planning is just too expensive. And I do see some people saying, I feel like estate planning is just too expensive. And before word processing, yeah, estate planning was expensive. When you used to have to fill out wills in triplicate, and if you made a single mistake, you had to tear the entire thing up and start all over again. But I want to assure you that today, estate planning is really for everybody. It's never been more affordable than it is today. And again, I have some bonuses that I'm going to offer at the end to make it even more affordable for you to get a great estate plan in place. And maybe you're worried about jinxing yourself. And I do see somebody is fessing up to the fact that they are worried about jinxing themselves. Don't worry. I have done dozens of estate plans. And luckily, I've never seen a correlation between doing an estate plan and having something happen to a client. In fact, I always say my clients tend to live more intentionally and get more enjoyment out of their lives because a weight has been lifted from their shoulders. And now they know what is going to happen when they're gone. I know that some of you said that you do have an estate plan in place. And if you do have an estate plan in place, I'm curious, is there something on this list that resonates with you that you want to learn about tonight? And even if you don't have an estate plan in place, is there something on this list that really resonates with you and that really speaks to you and is something that you're interested in hearing more about? Maybe you're here because you've completed an online will, or you're thinking about doing an online will, and you want to know if that do-it-yourself kind of online will is going to be okay, and if it's going to protect the people that you love. Or maybe you did a plan a long time ago, and now you just want to make sure that that plan isn't outdated and that it's going to take care of the people that you want in the same way that you believed it was going to when you created that plan. Or maybe you just want to get a better understanding of your plan. Maybe the attorney that helped you create the plan in the first place tried to go through things quickly or didn't actually explain or educate you along the process. And so you have a plan, but you're just not sure exactly what it says or what it means. If you're here for any of these reasons, I just want you to know that you are in the right place. I'm going to be speaking to all of these questions and concerns tonight, including the concern of how much is this going to cost? And if you have any other questions that you really want to bring to my attention or any other concerns, again, I hope that you'll look to the chat box or look to the Q&A box and share those questions or concerns with me. That's what I'm checking over here. And I'm going to keep monitoring it throughout the night so that I can answer those questions for you. All right. Again, I just want to let you know that you're in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you did an online or fill in the blank will, or if you're thinking about doing an online or fill in the blank will, but you're not sure if it's going to work and if it's actually going to give you the results that you want. And you're also in the right place if you're nervous about how much this is going to cost. That's one of the top questions that I get. It's one of the top concerns that I hear is, how much is this going to cost? Isn't this just for rich people? I'm not sure that I can afford this. But I want to give you peace of mind around this tonight. And so I'm going to tell you actually exactly what kind of fees you can expect to pay to get an estate plan done. The reality is, estate planning isn't about you. It isn't about us, right? And this is something that my wife and I realized when we were updating our estate plan somewhat recently. Estate planning is really about the people that we love and making sure that we have everything in place for them for when we can't be there to make things okay for them. And your loved ones are going to know whether or not you lived up to your promise to take care of it at that moment. I just want to say these are my three kids, and from left to right, it's Margaret, Ben, and Elizabeth. Margaret now is 4, Ben is 9, and Elizabeth is 6 years old. And they're the ones that I wrote my plan for to make sure that they're taken care of. So here are the things that we're going to talk about today. We're going to talk about planning for incapacity. We're going to talk about who can make healthcare decisions for you if something happens and you're in a coma, or if something happens to you and you are suffering from dementia and you're not able to make healthcare decisions or financial decisions. Who are the people who can step into those roles, and what does it look like to get somebody to step into that role? We're also going to talk about planning for when you pass away. And if you have minor children, that means who's going to get guardianship of the kids? And what is that going to look like? For all of us, it's going to mean a court process called probate. Unless we do some planning, there's a court process called probate that takes a lot of time. It's expensive and is also public in nature. Planning for when we pass away, we're also going to talk about estate taxes. We're going to talk about something called unclaimed property and the Minnesota Department of Unclaimed Property, and how property ends up there, how it ends up in that Minnesota Department of Unclaimed Property. We're also going to talk about your intangible assets, things like your stories and your values, and how you can make sure that you share those with the people coming after you. But before we do that, I would just like to tell you a little bit more about my background, just so that you know who you're spending the evening with here. So this is my family, and we live in Bloomington, Minnesota. My wife's name is Tobin, and my kids, this time from right to left, we have Ben, Margaret, and Elizabeth. And my family is really my whole world. I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my first child, Ben, was born. And there you can see me holding him for one of the very first times on his first day in the world, which also happened to be Mother's Day 2012. We have 2 Mother's Day babies, in fact. Funny stories. After law school, I found a job with a small estate planning and tax preparation law firm, and I loved the clients that I was able to work with. But at the same time, I didn't always feel like I was providing the value that my clients deserved. And so a little after 3 years, I actually ended up leaving that law firm. And this is a picture from my last day there. Oh, great. I see somebody has a question. Discuss the pros and cons of needing a trust. I promise you that I will dedicate time to talking about the pros and cons of needing a trust, and really who they're for and who doesn't need a trust. Great question. Someone has to graduate at the bottom of the class. Now, this was not said about me. I just have to say that from the start. This was actually something that was said by my parents about a negative estate planning experience they had with the attorney who planned my grandmother's estate. And I remember my mom in particular saying this: someone has to graduate at the bottom of the class. And there was a big reason for that. It wasn't this attorney's knowledge, actually. I don't think this attorney actually probably was last in their class. Maybe they were, I don't know. But I think this attorney was practicing under a faulty estate planning model. I call it planning for death, and I'm going to talk more about that later. But first, let's start getting into some aspects of estate planning. And here I want to share the last poll question that I have for you, just to get kind of a pulse of the room here and find out a little bit more about the demographics that we have here represented tonight. I'm going to talk briefly about guardianship, and guardianship really only applies for people with minor kids. And so it may not apply in your situation, but you probably know somebody that it applies to. Maybe you have grown kids with minor children, or maybe you have neighbors or nieces or nephews or grandkids somewhere that have minor kids, and that this is a pressing concern for. And so the first thing that I want to talk about is short-term guardianship. And short-term guardianship is what happens when you don't come home. What happens when the kids are staying with the babysitter and there's no plan in place, and that babysitter ends up calling the police and saying, Mom and Dad didn't come home. I don't know what to do with these kids. Please help. Please help me find the parents. Please help me figure out what to do with the kids. And what happens then is that the police will come to the house and they'll try and figure out where those kids go. And most often, the safest thing for the police from a liability perspective is to make sure that those kids end up with Child Protective Services and keep them with Child Protective Services until a legal guardian can be identified for those kids to stay with. And I'm not trying to knock Child Protective Services because they are spread thin and they don't have a lot of resources for the work that they do. But I can tell you, I have 3 minor kids. I don't want them having to spend any time with Child Protective Services. I don't want them having to spend any time with any kind of foster care situation. I know who my kids would be best kept with, or who would be best to keep my kids if something happens to my wife and I. And that's why my wife and I have made short-term guardianship nominations, and that we've actually put pen to paper and made sure that those documents are legal, and that the police will have somebody that they can call to give our kids to, or to come and stay with our kids. Thank you also for sharing on that demographics question. So we have short-term guardianship. That's what happens in the immediate term. That's like an immediate guardian. We also have long-term guardianship. And long-term guardianship is who is going to raise the kids until the age of 18. And even if you don't have a plan in place, there is a plan. And that plan is to have a judge decide what's in the best interest of the kids. Unfortunately, it's probably a plan that you're not going to like, because they're not you. They can't make the decisions that you can make about the people in your sphere and who would be best to take care of the kids. You probably know who the kids would flourish with, where they would thrive, where they would really grow in leaps and bounds, and who is the Uncle Larry type that they wouldn't do well with and that wouldn't make sense to have take the kids. And it's really important, if you have minor kids, or again, if you know somebody with minor kids, that they make sure that they get that long-term guardianship nomination in place. They make sure that it's legal, and they make sure that it's going to stand up and take care of the kids if something happens to them. All right, so I didn't see a lot of people with minor kids. I promise I am mostly done talking about minor kids. So we'll go ahead and get into talking more about the assets and about how assets transfer to the next generation. And if you don't have a plan in place, or if your plan is based on a will, there is a plan for you in the state of Minnesota. And this is true in most of the states across the country. There's a state plan built in, and that state plan is a court process called probate. And probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors. When you pass away, your creditors want to make sure that they get paid. Maybe it's your mortgage. Maybe it's a home equity line of credit. Maybe it is the loan that you took on your vehicle. Maybe it's a loan that you took on your furniture, whatever it is, whatever kind of debts that you owe, credit card debt, whatever it is, your creditors want to make sure that they get paid. And so they have this one size fits all process called probate that transfers your assets from your name and the name of your estate to the personal representative who can actually make sure that everything is collected and inventoried and that all of the debts are paid out, and make sure that those assets go to the people that they should go to, including creditors, including whoever you dictated in a will, or whoever the state's plan for you says should receive those assets. And the state's plan for you basically says, to your children, to your grandchildren, lineal descendants of you, that's where they look first. If they don't find anyone there, then they look up to your parents, and then they look to your brothers and sisters, nieces and nephews, and down to your grandnieces and nephews, and down that direction. Again, if they don't find anyone there, then they go up to they go up to your grandparents, and they look at your aunts and uncles, your cousins. They're going through this process of looking at different people who might receive, but it is all written into the statutes. It's all written into the laws. And I got to tell you, it often isn't the way that people want. It isn't the people that you want to receive, especially if it gets beyond the children or beyond the grandchildren. Oftentimes it is somebody that you don't really want to receive. And so if that's a concern for you, I hope that you'll let me know. It's something called intestacy statutes. And if you have a concern about what the intestacy statutes say in your case and what it will mean for your estate after you're gone, I hope you let me know. But let me talk a little bit more here about the court process called probate. Probate is slow. In Minnesota, probate takes a minimum of 6 to 12 months from the death of the person in question. And more often, it's taking something like 12 to 18 months to get through the court process called probate. It is slow. It's just built to be slow. The court wants to make sure that your creditors have plenty of time to come forward and make sure that they get paid. And so there's a lot of processes built in. There's a lot of bureaucracy and different forms that need to be filed and different things that need to be filed with the court. It's just a very slow and laborious process because as well, again, it's a one size fits all process. So it's the same process that Prince's estate goes through. It's the same process that somebody's estate goes through who only owes debts and doesn't really have any assets. It's the same process on both ends of the spectrum. And so it's just built to be slow. It's built to be expensive. We'll have a moment to, or I'll have a minute to actually calculate what probate might cost in your case here in just a little bit. But probate is estimated to cost something between 3 to 6% of the gross value of your estate. And so you can imagine if all that you have is a house that's worth $400,000, your cost of probate is already probably going to be somewhere between $12,000 and $24,000. And that's composed of all kinds of different fees and costs that are built in. There are court filing fees that are just baked into the process that you can't avoid, and publication fees because you need to put out a publication to make sure that all your creditors are notified that you have died. There are also attorney's fees for getting you through this process, through the court process. There are executors' fees, appraisers' fees, filing fees, creditors' fees, bond premiums, all kinds of different fees are baked into this court process, which again, we estimate that it's 3 to 6% of the gross value of your estate because the gross value of your estate generally tells us what the complexity of the court process is that we're going to have to go through. And again, we'll have a chance to actually calculate for each of us what that might be with a little back of the envelope math. Probate is also public, and that is something that a lot of people don't know, but I'm showing you here the last will of Anna Nicole Smith. And I was able to get this because this is in the public domain. When something gets filed with the court, it has to be made public, or it is made public by that filing with the court. And all you have to do is go down to the courthouse where that document was filed, and you can request those documents. They can't be kept confidential. The public needs to know what is in that will. And not only does the public need to know what was in that will, the public also needs to know an inventory of your assets. What kind of assets did you have? When did you have when you died? And what do those assets look like? And who ended up receiving those assets? Who were those assets distributed to? And it sounds crazy that the court would make all of this information public, especially in our modern day when there are predators out there who are looking for chances to prey on people who are receiving a lot of money and don't know what to do with it exactly. But it is the fact of the court process, or the process of probate, that everything is public. Here's a terrible thing, another terrible thing. The news will get better in just a minute, I promise. Another thing is that if you don't have a plan in place, or if you haven't changed this plan in your will or in your estate planning documents, your children would be entitled to all of your assets outright and without any restriction at 18 years old. And I think we all know stories about people who received assets at too young of an age, and they received assets at too young of an age, and it stunted their ability to deal with finances. It maybe stunted their education. Whatever the case is, 18 is too young to receive the kinds of assets that somebody might receive in an inheritance for almost everybody. Not everybody, but for almost everybody. And so there are things that you can do to protect those assets and to make sure that people aren't receiving them at such a young age. So here's our opportunity to actually calculate our probate estate. And what I've done here, I have put some example assets here. I know that this is not a picture of what we all have. Some people are going to have significantly less assets than this. Some people are going to have significantly more assets than this. But this is just an example that I am putting forward to give us kind of an idea of what probate might cost. So here you can see there's a family home with a fair market value of $300,000. There's a rental property worth $250,000, some furniture, some automobiles, some stocks, bonds, and bank accounts, and a business interest as well. And here you can see I came up with the total $850,000 for this estate. Now, the way that you can calculate very quickly what 5% of this estate would be, which is a fair estimate for the gross, for the fees that might be charged on a probate. You move the comma over one place, so you have 85,000, and then you divide that number in half. And so that's how I got this estimated probate costs and fees of $42,500. And that's not just attorney's fees, although attorney's fees is a big part of that, but there are court fees and appraisal fees and accounting fees and business valuation fees, bond fees, personal representative fees or executor fees, all kinds of other miscellaneous fees that go in and will kind of eat away at the estate that should be going to the person that you want to receive the estate. But there is good news. Probate is voluntary. But before I tell you exactly how probate is voluntary and how you can escape probate, I just want to throw a slight wrinkle into the example that I provided before. Certain assets should not go through probate because they actually go by beneficiary designation. And if you've ever taken out a life insurance policy or had a life insurance policy taken out on your behalf, maybe from an employer, you know that you put beneficiary designation on that life insurance policy to dictate exactly where that life insurance policy should pay out to if something happens to you. And the same is true with retirement accounts. If you have a retirement account, you can put a beneficiary designation on that retirement account and it will pay out directly to somebody. And because those go by beneficiary designation, it's kind of an operation of law. It doesn't have to go through your estate. It's not something that you were really holding in your own personal name, but by those beneficiary designations, they transfer automatically. And so they avoid probate unless those assets are going to somebody under the age of 18. If they are going to somebody under the age of 18, then unfortunately, there is a process in the probate court called conservatorship where somebody needs to step up and go through a painful process in order to actually get the right to collect those assets and hold them on behalf of the child. And they're going to have to make annual accountings. They're going to have to do all of this extra work in order to actually hold those assets for the minor. And so here you can see if the life insurance and if the retirement accounts were payable to a minor, all of a sudden those add significantly to the expense of probate, as well as the pain of the process of probate, and as well as the time that that probate is going to demand from the people in that family. But there is a foolproof way to avoid probate. You can avoid this entire court process, this lengthy 6 to 12 month or 6 to 18 month process. You can avoid almost all of the fees that are incorporated into the probate process. And you can do that by fully funding a living trust. And so I know that I had this question earlier. Somebody wanted me to discuss the pros and cons of a trust. And really, that is one of the biggest pros out there, is that you can avoid probate. You can avoid the cost of probate. You can avoid the time that probate takes. You can avoid the fact that probate is a public court process, and keep everything really private by creating a trust. There are a ton of advantages to a trust, but a trust isn't right for everybody. If you don't own real estate, or if you don't own real estate and you own assets worth less than $75,000, there is a really simple process that your estate can go through without having to go through the probate process. And again, the restrictions on that are if you own real estate, you can't go through this simple process. If you own assets in excess of $75,000, even if you don't own real estate, you still have to go through that probate process. But if you don't own real estate and you're under 75,000, there's a process called affidavit for collection of personal property that is just fine that you can get through. But a trust is going to provide a way to actually avoid probate, because if an asset is in your trust, it's no longer in your personal name. And if that asset is in your trust, then a successor trustee is going to be able to step into your shoes immediately and be able to interact with that asset and take care of it in the way that you would want it to be taken care of. And maybe that means selling the asset and keeping the proceeds in the trust. Maybe that means distributing out the proceeds of the trust to the people that you want to receive them. Whatever job you have for the trustee, they can step in and do that immediately. Whereas a personal representative has to be approved by the court and has to go through a waiting period where creditors are able to come forward and ask to be paid. Those processes don't happen for a trust. You can avoid all of that for a trust. So that's one of the really big pros of having a trust. One of the cons of having a trust is generally more expensive to create right out of the gate. And so if you don't have a need for a trust, if you have assets that are less than $75,000 and you don't own any real estate, then oftentimes it doesn't make sense to have a trust. Or if you hold your assets in a certain way and you're okay with beneficiary designations, doing certain things with your assets, and I can get very specific on that with you if you will, reach out to me and schedule a meeting with me. I can be very specific about exactly what situations you can work around where you don't need to have a trust, where you can do things very effectively without a trust. But really, again, if you want to avoid probate, if you want to avoid the time, if you want to avoid the public nature of probate, and if you want to avoid the expense, that 3 to 6% of your the gross value of your estate, there is a foolproof way of doing that, and that's by creating a living trust, which is an agreement that you write with yourself, but having a lawyer write this agreement with yourself and then fully funding that trust, meaning taking all of your assets and putting them into the trust. And so if you have investment accounts, things like brokerage accounts or stock holdings somewhere, you retitle those investment accounts into the name of the trust, and that puts them into the trust. If you have, and we all have bank accounts, then you need to go down to the bank account and sign new signature cards at the bank where you are you're signing it over to yourself as a trustee as opposed to yourself as an individual. And by signing it over to yourself as a trustee, you're still able to interact with those bank accounts. You're still able to use the money and spend it on whatever you want to spend it on, because you're also the beneficiary of your trust. And it's a revocable trust or a living trust. You're still able to use the money for whatever you want to use it for. But again, it isn't in your personal name. It doesn't have to go through the probate process and get resolved in your estate. A successor trustee is able to just step into your shoes and take over on that bank account and be able to write checks and do whatever needs to be done, whatever the trust instructs that person to do. They can step in and start doing it right away. For real property, you execute deeds in order to transfer that property into the name of the trust. If you have stock or bond certificates, then those need to be transferred into the name of the trust. And it still happens from time to time that people have the paper stock or bond certificates. And I just helped somebody recently who had formed a corporation for their business. And so we needed to do a stock transfer and make sure that those stocks were in the name of their trust. And that's very doable. It's not complicated, but it does help to have somebody who's an expert to help you with that and to make sure that you do it the correct way. And then assign personal property into the trust with something like a bill of sale or an assignment of personal property. Then you have life insurance. If you have life insurance and retirement accounts, changing the beneficiary designation so that they ultimately point to the trust as opposed to pointing to individuals, because you want the provisions of the trust to dictate where those assets go. It's much easier to have the trust determine where everything goes, as opposed to trying to balance all of these different beneficiary designations so that so-and-so, son number one receives this retirement account, and son number two receives this retirement account, and daughter number one receives this life insurance policy. It gets really complicated and confusing if you're trying to juggle beneficiary designations, especially as those retirement accounts get drawn down, or trying to put somebody on a bank account or something like that gets really complicated. The easy way to do that is to have a trust and to have things go from the trust in the way that you want them to go, so that it's just really clear everything is in one place. And if you ever need to make changes, you just go to that one place, you go to the trust and rewrite the agreement so that it says what you want it to say, and that the distributions happen in the way that you want them to happen. All right. This is the point where I get to give everybody really good news, or what I think is good news. A lot of people worry about estate taxes, and they worry about, what am I going to lose, or what are my heirs going to lose to estate taxes that they're going to have to be paid. And the good news that I have is that on the federal level, there is an estate tax, but there's also an exemption. And so for your first $11,700,000, you pay nothing in estate taxes. For your $11,700,000 and first dollar, you start paying estate taxes, and you start paying estate taxes all the way up to 40 cents on the dollar. Another good fact is that you can actually double that federal estate tax exemption if you're married. In fact, it happens automatically with something called portability, that whoever is the spouse that passes away last can adopt or can pull forward that their deceased spouse's exemption. The first spouse to pass away, they're able to use that exemption that the first spouse didn't use. In Minnesota, we also have an estate tax, and we have an estate tax exemption. This time, the estate tax exemption is smaller, but it's still an amount that doesn't affect most people, or where the estate tax doesn't affect most people. And the estate tax exemption is $3 million. So again, for your first $3 million, you pay nothing in estate tax to the Minnesota government. For your $3 million and first dollar, you start paying at 13 cents on the dollar, and you start paying up to 16 cents on the dollar as you get above that. Now, you might be thinking, I am over $3 million, but I'm not over $6 million, and I'm married, so I must be okay. And that is true. It's kind of true. In Minnesota, you actually have to do some estate planning in order to double that exemption. So in order to make that estate tax exemption $6 million for you and your spouse, you do have to do some active planning in order to make it happen. And it's complicated, but it is very doable for an experienced estate planning attorney to make sure that you're able to double that estate tax exemption. So again, if you're above $3 million, definitely reach out to me and make sure that you are able to double that estate tax exemption. If you're over $11.7 million, definitely reach out to me and make sure that that you're able to minimize the amount of estate tax that you need to pay. Will your assets be lost to the state? So right now, we have in the Minnesota Department of Unclaimed Property a significant amount of assets. And I don't see anybody trying to guess, but I'm just going to tell you right away, right now in Minnesota, there's over $700 million in the Minnesota Department of Unclaimed Property. And a big way that a lot of that money gets there is that somebody passes away, and the heirs, or the personal representative, or whoever is coming after them, just isn't aware of everything that that person who passed away had. They're not aware of all the assets. Maybe they're not aware of a bank account, or they're not aware of a certain stock that this person held. And so it just gets lost. And after a certain amount of inactivity, it ends up in the Minnesota Department of Unclaimed Property. And there is a process that you can go through to recover that property after the fact, or that your heirs can go through to recover the property after the fact. But it's a difficult process, and it's a process that you just shouldn't have to go through. It's very important that you inventory your assets and make sure that everything is collected somewhere so that the people who come after you will know exactly where they need to go in order to find everything. And that is part of my process, making sure that nothing gets lost. And I think this is especially important to me as somebody who's young and somebody with 3 kids, somebody who is still building their assets, their wealth, that I want to make sure that everything that I have is able to be used for my kids, is able to be used for their education or just for their growing and their general expenses of life. I want everything to go to them and to make sure that they're able to receive everything. And so for me, it was really important to make sure that I had an inventory of where everything is so that if something happens to my wife and I, somebody's able to step into our shoes and able to find everything. Nothing gets lost to the Minnesota Department of Unclaimed Property, but everything goes to my kids and is able to be used until they're to raise them and eventually go to them in an inheritance. This is really cool. You can actually make your living trust a real treasure chest. Try to say that 10 times fast. And what I mean by that is that you can actually build in asset protection to your trust. And asset protection means that you can protect their inheritance from things like divorce or things like a lawsuit in the case that they are in a car accident or ever sued at some point in the future. And this is a very cool concept. It's something very cool that I'm able to build into your trust if you want it, this asset protection to protect their inheritance, because you want them to enjoy that money. You want them to be able to use that money to enrich their lives. You don't want that money to have to go to a divorcing spouse or to some settlement at some point in the future. And we can build in that asset protection to make sure that their inheritance is used for what you want it to be used for. And I know that this is something very real for all of us right now, planning for incapacity or thinking about incapacity. And you may recognize the person on the screen here. The person is Terry Schiavo. And Terry Schiavo was a kind of a sensation across the United States in the early and mid 2000s. That Terry had a heart condition that ended up leaving her in a vegetative state. And there was an argument in the family. There was conflict in the family between keeping Terry alive, and then her husband didn't think that Terry would want to be kept alive in that vegetative state. And there was a ton of conflict between her husband, who didn't think that Terry would want to stay alive, and her parents, and Terry's parents believed that she would want to stay alive and that she would want to continue receiving medical treatments if there was any glimmer, if there was any hope of her pulling through, or any hope of her enjoying life in any way. And so there was a ton of conflict, and there were a ton of court cases, and it was a very expensive and frustrating battle for everybody. I can tell you that didn't need to happen. Terry could have made her healthcare decisions known. She could have made the decisions about whether she would want to stay on life support in that vegetative state or whether she would want to be taken off life support in that vegetative state. She could have made that known in a document called Healthcare Directive or a living will before she was in that situation. And this isn't to, backseat quarterback or 2020 is always hindsight. I understand that. But I just want to highlight that this is something that's really important, and that really can take a load off of our family's mind when it's something that they don't need to be thinking about, something that they don't need to be second guessing what our desires would be for ourselves, what our desires would be for our healthcare. We can let them know during our lifetime and during our capacity, our ability to make those decisions. We can let them know exactly what we would want and save them from having to try and decipher it when we can't be there to help them make that decision. So Talking about all of these things, talking about probate and guardianship of minor children, and talking about incapacity, planning for who can make healthcare decisions for you, who can make financial decisions for you, and talking about the Minnesota Department of Unclaimed Property, talking about possibly building in asset protection, talking about possibly owing estate taxes, talking about all of these things. You're probably thinking, what can I do today to do the right thing for my family? And what should I expect it to cost? Really talking about all of these things, and I think especially talking about probate and the expense and the public nature of probate and the amount of time that it takes, but really talking about everything, talking about guardianship and making sure that the kids are protected if a guardian is ever needed for them, talking about making sure that your wishes are known for your healthcare and for your finances in case you can't make those decisions. You can't be the person making those decisions for you. Talking about all of these things, you're probably either thinking, I need to create a plan, but do I do it myself or do I work with an attorney? And do keep in mind, not all lawyers are the same. But if you're thinking that your options lie somewhere here, I'd like to help guide you. I'd like to help you make that decision between doing it yourself and working with a lawyer, keeping in mind that, yes, I'm a little biased, but I do want to provide you the information and I do want to empower you to make the decision between those options. So first off, choosing, would you benefit from working with a lawyer? And the truth is, if you own more than just your personal belongings, if you own more than just cars, clothing, jewelry, furnishings, again, that $75,000 figure that we talked about before, if you own more than $75,000, if you own real estate in particular, then you would probably benefit from working with an attorney. You'd probably benefit from working with a lawyer to get your estate plan done. And if you want to ensure that the people that you love stay out of court and conflict and have someone to turn to when something happens to you, then you would probably benefit from working with an attorney. If you want a kids protection plan, which includes the short-term guardianship nomination, the long-term guardianship nomination, medical powers of attorney for each child, as well as instructions to caregivers, instructions to guardians, a whole kids protection plan to really make sure that they're taken care of if you can't be there to take care of them. Or if you want to avoid probate or estate taxes, or if you just want to protect your kids' inheritance from something like divorce or from something like a lawsuit, then you have to work with an attorney. You can't do those things on your own. They're just not available to do it yourself. And if you want to guarantee that your plan is going to work when your family needs it, then again, you really have to work with an attorney. One additional thing, if you want to give your assets to someone other than your kids, and you want to make sure that that gift is effective and that your wishes are carried out, then you should really work with an attorney to make sure that that wish is respected and honored and carried out. And I'll say, something that occurred to me because I'm a big do-it-yourselfer. I really love doing projects myself and doing things myself whenever I can. But recently, it wasn't so recently, it was over a year ago, I was getting the fishing rod ready to go fishing with my son. And I was putting new fishing line on this rod and reel. It had been shipped without any fishing line on it. And so I was putting fishing line on this reel, and I don't know what I did wrong. I don't know if I wound it the wrong way or if I just put too much on. Whatever the case was, as soon as I got done, as soon as I thought that I had it all set and ready to go for our fishing trip, and it was just a local fishing trip, but as soon as I thought that I was ready to go, that fishing line started jumping off the reel, and there was fishing line everywhere, and it was a tangled mess. And I was frustrated, but at the same time, it wasn't that big of a deal. I had done that myself. I had put that fishing line on the reel, and I had lost some fishing line. But let's be honest here, I lost maybe 30 cents worth of fishing line, and it happened immediately. I knew immediately that I had made a mistake and that and the cost wasn't high. I was able to snip the tangled fishing line off and just work with what I had, and it ended up working. It was all fine. I was able to go fishing that day with my son. That was a very good example of a do-it-yourself project that, that went wrong, but that didn't cost me an arm and a leg, and that didn't have a big risk of a downside if something went wrong. An estate plan is not like that. An estate plan, if you do something wrong, you're not going to know during your lifetime that you did something wrong. You're just not going to know. It is going to be something that your family has to deal with and that your family has to unwind later without having you there to help them unwind that mistake or whatever that problem was. And the risk is high. This is an area that takes a lot of expertise to plan in. It's something that is difficult for some experienced estate planning attorneys. And so it's something that you really want to make sure that you bring on the right team, or that you bring on the right person in order to help you get this estate plan done. Because again, you're not going to know if your estate plan is going to work or not unless you work with somebody who's been through it and has seen it and can make sure that you're making an estate plan that's really going to work for the people that you love. Now, I want to bring you back to this phrase: someone has to graduate at the bottom of the class. Now, you probably know that you would either benefit from working with an attorney, or you can probably handle it in a do-it-yourself situation. But how do you choose the attorney? How do you make sure that you don't end up with an attorney where your heirs are left at the end of the day saying, well, somebody had to graduate at the bottom of the class? You know, I reference my parents' experience with my grandmother's estate planning attorney because it is so relevant, and it's so real to a lot of people that they work with an attorney and they're just left with this feeling that that I'm not sure that attorney understood it any better than I did, and that's not what you should get from an attorney. That's not what your experience of an estate planning attorney should be. And again, I don't think it was that attorney's level of education or where they were at with the class. I think it was just the way that estate planning attorney planned. And again, I call it planning for death. And this is what it typically looks like. A typical estate planning attorney is going to work from form documents that are kind of set it and forget it. They're not going to keep money out of the Minnesota Department of Unclaimed Property. It's just not something that they focus on. The typical experience might avoid probate, but maybe not. Oftentimes it's just a will-based plan, and they know that they're going to have to go through probate, but that's okay with them because they also know that they're going to be able to collect the attorney's fees for going through the probate later on down the road. In fact, there's a term for that in the estate planning world. It's called when your estate planning practice matures. And it means that you're no longer writing those plans, but now you're helping them to go through probate. But that shouldn't be the case. An estate plan should help you avoid probate, and it can, and it should, and it will, if you work with the right attorney. The typical experience, it's probably not going to keep your family out of conflict, especially if you end up in probate. There's a lot of conflict that happens then in the court. A typical experience is only going to focus on money. It's not going to focus on any kind of intangible assets, things like your stories or your values. And oftentimes I hear from my clients that that's really what they would rather share. That's really the information that is most valuable to the family are those stories and those values that they want to share. Typical experience is going to leave assets to heirs unprotected without that asset protection from divorce or from lawsuits. In a typical experience, the attorney is not going to provide ongoing legal guidance because they're often charging hourly fees for future needs and causing kind of a rift in the relationship that you really should be having with them by charging those hourly fees every time that you reach out and every time that you try and contact them. Typical experience does not have the full kids protection plan, and so it's not going to adequately protect your kids. In fact, most often, what a typical estate planning attorney will do is just take care of the long-term guardianship of your kids in a will, which means that that long-term guardianship nomination doesn't even become effective until the will gets into the probate court and is accepted as a probatable will. And really, with the typical experience, you're going to end with this question: is this going to work when I need it to work? And that's never a question that you should have after you've worked with an estate planning attorney to get your plan written in the way that you want it to be written. I plan in an entirely different way. And I call it planning for life. And it's a totally different experience. I charge flat fees where you get to choose the fee. And I will show you in our meeting some different fee ranges. And you decide, based on your budget and based on what you want for your family, what is the best fit for you, and you can choose. Planning with me means that you can keep your money out of the hands of the state. And that includes estate taxes, that includes the Minnesota Department of Unclaimed Property. I'm able to help you take care of your money and make sure that it's stewarded to the people that you want it to go to. Planning with me means protecting your kids totally in the immediate, short term, and in the long term. And I know that we don't have a lot of people with young kids, but this is so important to make sure that they're taken care of in the short term and the long term. Planning with me means keeping your family out of court and conflict. That is such a crucial part of estate planning. And I believe that in order to have a really successful plan, it has to avoid court and conflict. Really, I'm a peacemaker at heart, and that's something that I'm really passionate about is making sure that the family is still intact, that there's not undue conflict as they're going through an administration at the end. Planning with me, it means that you're going to know that you made the right decisions. I am emphatic and I'm very strong on educating my clients and empowering them so that they are the ones making the decisions and they know what they're deciding when they make those decisions in their estate plan. That's very important to me. I don't want you to be a passive participant in your estate plan. I want you to be a very active participant in making those decisions and fully understanding what the decisions are that you're making. I'll give you guidance. I'll be there to guide you and help you, but they are your decisions. It's your family. It's your assets. And I want to make sure that what you want to have happen is really what happens. Planning with me means that you can protect the family money from outsiders, again, from things like divorce, from things like creditors. Planning with me means a lifetime of guidance and protection. Again, I charge flat fees. I'm not going to charge you hourly fees in the future for reaching out to me with emails or phone calls and asking me questions. I want you to ask those questions. I want you to update me as things change in your life. That's really important to me, that we're able to stay in contact, that we're able to stay in a relationship and keep your trust or keep your plan up to date. Now, there might be some charges if we make changes to your plan. If we have to rewrite your trust or rewrite a document or make edits inside of a document, there is going to be a fee to make those changes. But I promise you that we will talk about it before those changes are made, that we will agree together on a flat fee that makes sense to make those changes, and that we can work together on it in order to make it work for you. And I see somebody asking, is there an annual cost for a living trust? And no, there's no ongoing operating cost for a living trust. There's just not anything like that. A revocable trust is very easy to maintain. It's very easy to keep going forward. But again, if you have changes that you want to see made, there could be some charges. I also see a question here, and I'm sorry, I didn't mean to ignore this question. I'm just trying to get into more of the meat of the presentation here. But I see here somebody asking, how do you protect your home and assets if you have to go into a nursing home? Can the nursing home take it all? And I know that this is something that is on a lot of our minds right now. It's on a lot of people's minds, and it is becoming more and more common that people are spending some part of their lives in a nursing home. And nursing home costs are very high. They are something like $8,000, $10,000 a month in some cases, which is really extreme. There are ways to plan for nursing home care, and there are ways to plan for nursing home care. If you are 20 years old right now, there are very good ways to plan for nursing home care with things like long-term care insurance. Even if you're 30, 40, 50, long-term care insurance still might be a good option for you. But even if you're older than that, even if you are 70, 80, even if you're expecting to go into a nursing home next week, there are opportunities and there are ways to plan for the costs of nursing home care. And there are ways to work with your assets and to shift some assets around. In fact, I've even helped clients who are in a nursing home to be able to protect some of the assets that they have and still qualify for government benefits. The options keep getting slimmer and slimmer the further that you go. And so if that's a concern for you, if nursing home care is a concern for you and the costs of nursing home care are a concern for you, I hope that you'll reach out to me and that I can help you out as early as possible. Really planning with me, it means that your plan is going to work when your family needs it to work. And again, it's a gift that you're giving to the people that you love the most. So what should this cost? And I know that cost is on everybody's mind. I know it's a concern that everybody has when they start thinking about estate planning and when they start thinking that they need to get something done. And so just to provide a little bit of context before I tell you exactly what fee range you can expect to pay when you hire an estate planning attorney like myself, if all that you have is a house that's worth $400,000, and I'll admit that's a nice house, that's a very generous house for many of us, but for some of us, especially with the way that real estate prices have gone recently, this isn't out of the norm as much as it used to be. And so if you have a house that's worth $400,000, 3% of that already is $12,000. $12,000 you might expect to pay towards probate, or that your estate might have to pay towards the costs and fees associated with probate. And if you have assets over $3 million, then this planning will save your family at least 13 cents on the dollar for every dollar in excess of 3 million. Again, that's the Minnesota estate tax exemption, which kicks in at 13% and goes up to 16% on assets that are in excess of $3 million. A typical death plan from a typical estate planning attorney who is not going to keep your family out of court and conflict, isn't going to ensure that your assets are maintained in the family and get to who you want them to get to, but might end up going to the Minnesota Department of Unclaimed Property. Typical estate planning attorney whose plan is only going to cover your money. It's not going to cover your kids' immediate care. It's not going to cover your values, insights, stories, and experience. It's not going to cover those most valuable intangible assets that are so often lost. $1,500 is a minimum of what you can expect to pay a typical estate planning attorney for an estate plan. Or you can meet with me. I am a personal family lawyer, and I'm a part of a network of personal family lawyers that believes, again, in educating and empowering our clients and making sure that their estate plan does exactly what they want it to do. And you can learn exactly what your family needs. You can even choose your own fee, again, likely to range somewhere between $2,000 and $8,000. Again, you're choosing your own fee based on your budget and what you want for your family. And I'll lay all those flat fee packages out for you so that you can make the best choice for your family that you know is right for them. And you're going to know that your plan is going to work when you need it to work. So again, there's the, after all the buildup, that's what you can expect. That's the cost of working with an attorney like me, somewhere between $2,000 and $8,000. And I'd like to make it really easy for you. I'm going to go ahead and post my booking link in the chat right now. So if you don't have the chat open yet, go ahead and open it up and you should see the link. You should be able to click on it and you're going to see I don't have any appointments available here in November, but I do have some appointments still available in December. And I do have availability in January and February if you're looking to book out that far. But what you want to do, click on that booking link, click on Family Wealth Planning Session. And that Family Wealth Planning Session is a session with a value of $750. I want to give you that session for free for being here and attending this webinar tonight. I do want you to commit to doing some homework ahead of time before our family wealth planning session to make sure that our family wealth planning session together is productive and that we're able to get through everything and really educate you in the way that you need to be educated about your own estate and exactly what's going to happen. But I want to give you that family wealth planning session for no charge. It's a 2-hour-long session with me, where we'll talk about everything that you have and everyone that you love. We can do that session remotely, or we can do that session in person if you want, if remote is an issue. But most often I've been doing those sessions kind of like this, just over Zoom. And we talk together and we get to know each other a little bit. And we talk about your family and we talk about the different dynamics and relationships in your family. And we talk about your assets and we talk about some of the things that we've talked about tonight. We talk about who would be the person to step up and make sure that all of your assets are collected, that all of your assets are going to get to who you want them to get to. We're going to talk about probate and what probate might look like for your family and what probate might look like for your assets and exactly what the probate court procedure is and what probate might cost in your case. And we'll talk about estate taxes and whether estate taxes are going to be an issue for you or not. We'll talk about if estate taxes are an issue, how can you avoid those estate taxes or how can you minimize the amount of estate tax that you need to pay? And we're going to talk about incapacity. We're going to talk about who can make healthcare decisions for you, who can make financial decisions for you. And if it's difficult to choose, if you're having a hard time choosing, I can provide guidance in exactly how to choose those financial and healthcare decision makers in your family and in your world. And we'll talk about all kinds of things, how the money should go to the people that you love, when they should receive and how they should receive and what that looks like. All of that is included in that family wealth planning session. And so I want you to click on my booking link and I want you to click on family wealth planning session, find a time that works for you to have that meeting with me. Again, we can do it totally virtually. That has really been the preference for the vast majority of my clients. It works pretty seamlessly. But again, I also understand that there are some accessibility issues and that sometimes meeting over Zoom is difficult. And so if Zoom doesn't work for you, if it's not ideal, that's okay. We can meet in person. And what I do, because I have a virtual office where most of my meetings are virtual, I actually travel to my clients and I can meet you in your home. Again, if Zoom isn't an option for you, if it just isn't going to work for you. But I want you to click through and I want you to see my times and schedule a family wealth planning session for me. And in fact, I want to sweeten the deal here as well. I will give you $250 towards the estate plan of your choice if you reserve your appointment by the end of the week this week. Now, what I mean when I say the end of the week, I mean the end of the day, Saturday. If you click through, find a time, and you actually reserve, it doesn't have to, our appointment doesn't have to be before Saturday. And you'll see that's not even possible because I don't have any times left in November. And the reasons for that, I take on a very select number of clients because the work that I do, I give my clients a lot of my time and attention, and I help them. I really guide them and make sure that they are well cared for throughout the estate planning process. But I know that that takes a lot of my time. And so I limit the number of clients that I take each month in order to ensure that I'm giving my clients the time and attention that they need. But again, I want to give you $250 towards the choice of your plan if you choose to continue and do a plan. The family wealth planning session with me is a no obligation session. It's a no obligation meeting where we're just going to talk about things, and you'll have the decision in that meeting. You'll be able to decide in that meeting whether you want to continue and whether you want to complete a plan. And if you do, that's great. If not, again, I just want to be able to meet with you and get specific on exactly what is going to happen in your situation. I apologize. I see that there's a question over here. If you use medical assistance, does the county take all of your assets? And that's a really fantastic question. There is a process in Minnesota called estate recovery. And estate recovery is a process where the state will look at what is left after you're gone. And they'll look at things that are in your probate estate, but they'll also look at things that are in something like a revocable trust or a living trust. They'll look at your home. They'll look at everything that is left after you're gone. And if you have used medical assistance, if you have had some use of medical assistance during your life, then the state will expect to recover something from your estate after you're gone. It is a sad fact, but it is true. That is what happens when you use medical assistance or it's known more colloquially as Medicaid, across the United States. But yes, there's an estate recovery process that the state will try to recover against your estate after you're gone. There's some ways to combat this. There are some ways to try and spread some assets out during your lifetime. It's definitely not something that you should be doing on your own. Trying to gift assets or something like that could actually have the effect of disqualifying you from receiving medical assistance and for a long time as well. So if it's something that you're concerned about, I hope that you'll reach out to me. I hope you'll either schedule a family wealth planning session or at least schedule a phone consultation with me. And I see here is that the same for MinCare. You have to repay. And I don't believe so. I think MinCare has a separate treatment because if I remember right, anyway, you can reach out to me and I can give you a more explicit and a clearer answer. But no, I don't believe it's the same with MinCare. But again, it depends on the overlap and where you are receiving benefits from and what those benefits look like. But no, I don't think MinCare has quite the same treatment. But it really depends on the assets that you're receiving. Can't give you a perfect answer on that. I'm sorry, but I hope that you'll reach out to me and I can answer that in more detail. So next steps, please schedule your free family wealth planning session with me. And again, use the $250 towards the plan of your choice. I want to give you that $250. I want you to qualify for that and I want you to enjoy it. You deserve it for being with me here tonight and for educating yourself. And let me tell you, estate planning is a momentum thing. You have to keep the momentum going in order to get an estate plan done. And you've already started that process. You have committed over an hour to be with me here tonight, but you have to keep going and you have to continue the process. Otherwise, you risk losing the momentum and you risk, unfortunately, having a situation where you look up all of a sudden and a year has gone by and you haven't gotten your estate plan in place. And I've seen it happen before. I've seen it happen to, very unfortunate consequences before. But I want to give you that $250 again, to keep your momentum going and to keep you going in the right direction. I am just going to post on our live Facebook page in case anybody is over there watching me that they want to book. I've posted my link over there, so now they have my link where they can access my calendar as well. I don't see any extra questions coming through. I hope that you have clicked over and taken a look at my calendar. Again, I want you to book and I want to have this meeting with you. I really love meeting with people and I love talking to them about their families and talking to them about their assets and making sure that they are fully educated and fully empowered on what is going to happen with their estate and with their family after they're gone. And so I am going to go ahead and wrap it here. It's after 8 o'clock already. I do see that some appointments have come through and that's fantastic. I love seeing that. I'm really looking forward to meeting with you. I hope that you are one of the people who has scheduled a meeting with me and that we'll be able to meet together. I'm really looking forward to it. And I really want to thank you for joining me here tonight. And I can tell you your family is going to thank you that you're in here getting this taken care of. And your future self is going to thank you that you've been here with me tonight, that you've educated yourself, that you have more information than you did an hour and 15 minutes ago, and that you are closer to getting an estate plan in place to protect the people that you love. So thank you again for joining me here tonight, and I hope that you have a great evening. Take care.